Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello, this is Alexis Gupta. I'm an FDA and healthcare associate in the Nashville office of K&L Gates. My practice focuses on both FDA and healthcare compliance and regulatory matters.
Hello, this is Cindy Ortega. I'm a healthcare associate in the Chicago office of K&L Gates. My practice focuses on healthcare regulatory matters and provider reimbursement disputes. Today, we are discussing the FDA's latest guidance on informed consent regulations for clinical investigations. This guidance is meant for institutional review boards, clinical investigators, and sponsors.
Yes, the guidance document was issued by the FDA on August 15th, and this guidance is the finalized version of the draft that was first released in 2014, so almost 10 years ago. With that said, this finalized document supersedes FDA's 1998 Guide to Informed Consent. So overall, the new guidance is really intended to assist IRBs, clinical investigators, and sponsors in complying with informed consent regulations, and it contains changes that are intended to modernize the informed consent process overall.
Okay, so let's start with some basics. The FDA's informed consent requirements are set forth in FDA's regulations on protection of human subjects, and this specific guidance focuses on those requirements. The consent process is more than just getting an individual to sign a paper. Clinical investigators need to provide prospective subjects or their legally authorized representative with adequate information about their participation prior to them enrolling as subjects so that they can make an informed decision regarding their participation. Investigators also need to facilitate the prospective subject's understanding of information, give an opportunity to ask questions, and obtain a voluntary agreement to participate. Lastly, investigators need to keep providing information as the investigation progresses. Therefore, this is a continued endeavor as opposed to one-and-done deal. Nevertheless, of course, a physical form is still involved. The consent form must have contact information, the basic elements of the clinical investigation, and the date of the agreement. Alexa, could you walk us through the basic elements of the consent form?
Sure. So the basic elements of informed consent are: first, a description of the investigation. Second, any reasonably foreseeable risks or discomforts to the subject. Third, any benefits to the subject or to others expected from the research. Fourth, a disclosure of appropriate alternative procedures or courses of treatment that might be advantageous to the subject. And fifth, a statement describing the extent, if any, to which confidentiality of records identifying the subject will be maintained. And for research involving more than minimal risk, an explanation as to whether any compensation or an explanation as to whether any medical treatments are available if injury occurs, and if so, what they consist of or where further information may be obtained.
As a final general note, I'll mention that informed consent cannot be sought or obtained under coercion or undue influence. The language of the information must be understandable to the subject for both language and level, and it also may not contain any language where subjects are made to waive their legal rights or release the investigator from negligence liability. Changes from the previous draft guidance include new language on examples of coercion and undue influences.
So switching gears, the documentation of informed consent is also an important piece to remember. Informed consent must be documented by a written form that is approved by the IRB and signed and dated by the subject, and then the subject must be given a copy. There are two specific circumstances in FDA's regulations that are exceptions to this rule, which we won't discuss now, but they have to do with research that presents a minimal risk to subjects and then emergency research. So traditionally, informed consent has been obtained and documented in a face-to-face discussion using paper consent forms. However, this new guidance states that technologies are available that may serve as an alternative to the paper consent form in the informed consent process. The new guidance also explains that even in the context of paper consent forms, there may be certain circumstances when an alternative to the face-to-face discussion may be appropriate. if those methods allow for an adequate exchange of information and documentation, as well as a method to ensure that the signer of the consent form is the person who plans to enroll as a subject. For example, the consent form may be sent to the subject via fax or email, and the consent discussion may then be conducted via telephone or video conference, and the subject can access the consent form during such discussion. After the discussion, the subject can sign and date the consent form and return the document via email or just bringing it to their next in-person visit. As far as the contents of informed consent forms themselves, the regulations provide two choices: either a long form that includes all of the elements of informed consent, or a short form that states that the elements of informed consent have been presented orally to the subject and met. So switching gears a bit again, and to go over some of the responsible parties in relation to informed consent, we'll start off with the IRB. So the FDA requires that an IRB approve, require modifications to, or disapprove all research activities covered by the IRB regulations. One important part of that is that IRBs must review all materials used in the informed consent process. This includes the informed consent form, recruitment materials, and information provided in addition to the informed consent form. As a part of that review, the IRB will review the wording in the consent materials, as well as the overall length and presentation of information. Consent forms that are long, complex, or legalistic may overwhelm prospective subjects and may inhibit reading of the full document and understanding of the relevant and important information. The IRB is tasked with ensuring that technical concepts and terms are explained so that the anticipated subject population can understand all provided information adequately. A new recommendation in this guidance is that pictures, diagrams, or other visual aids may be used to improve understanding of medical terms or how an investigational product functions. So, as stated before, all information given to subjects as part of the consent process must be approved by the IRB. And during the clinical investigation, there may be new information about the research or changes to the clinical investigation that may arise that affects subjects. In that case, FDA recommends that IRBs have procedures in place for the timely review of such new information and changes, including procedures for the clinical investigator or the sponsor to notify the IRB of any new findings that arise that are relevant to a subject's decision to continue participation. When new information or changes in the clinical investigation warrant revisions to the consent form or protocol, the revisions must be reviewed and approved by the IRB before the revisions are initiated. This new guidance does clarify that administrative changes such as correction of typographical and spelling errors and changes in telephone numbers, for example, must be submitted to the IRB to keep on file, but they do not require formal review and approval, which is a clarification that previously was not known.
Let's talk about the impact of this guidance on clinical investigators. So, as we know, clinical investigators must obtain legally effective informed consent from each subject before they take part in the clinical investigation. Notably, this type of consent goes a bit beyond FDA requirements because it also needs to meet all federal, state, and local laws. Clinical investigators need to first notify the IRB regarding the consent process, including who is conducting the consent discussion, along with any information given to the subjects as part of their informed consent. The IRB then needs to approve it. This is crucial to understand because an investigator may not begin the informed consent process until the IRB approves its consent form along with all the information given as part of the consent process. Similarly, if during the course of the clinical investigation, the investigator needs to revise the consent form to address new information, as Alexa discussed, such as change to the protocol or new safety information, it will need new IRB review and approval of the revised form. Depending on the changes, the IRB might require subjects to consent again. There's two quick highlights that I would like to make. The first one being, if the investigator delegates the responsibility to obtain consent, the FDA expects that the individual to whom the responsibility is delegated to will be qualified. The qualifications include education, training, experience to perform this activity, and importantly, they need to know about the investigation to answer questions appropriately. The investigator must have a detailed plan for the supervision and training of the staff, including for the informed consent process. This is crucial because regardless, the investigator remains responsible for ensuring that proper, legally effective consent is obtained. The second highlight involves the disclosure of financial relationships and interests. Clinical investigators need to consider these questions, but it is ultimately the responsibility of the IRBs to determine whether subjects should be provided with information regarding the source of funding, funding arrangements, or financial interest of parties involved as part of the consent process.
Thanks, Cindy. What about guidance for sponsors?
Yes, so in the new guidance, the FDA acknowledges the common practice of sponsors of using template consent forms. Sponsors often provide clinical investigators with a model consent form that may be adapted by the clinical investigator to meet local needs, and then the FDA generally directs comments back to the sponsor. If modifications are needed, the sponsor is responsible for providing them promptly so that it can move on for IRB approval. Notably, clinical investigators should provide the sponsor with a copy of the consent form approved by the IRB. Lastly, I want to briefly cover multi-center clinical investigations. For multi-center clinical investigations reviewed by more than one IRB, if local IRB review results in substantive modifications to the consent form, the FDA expects the sponsor to share the revisions with all investigators and their IRBs. Alternatively, if the multi-center clinical investigation has a central IRB cooperating with local IRBs or human research protection offices, the revisions should be forwarded to the central IRB. The one caveat would be for medical device studies that require submission of an IDE application because those should be submitted to the FDA. If sponsor personnel will be present during the procedure or follow-up, or if the activities of the sponsor personnel directly affect the subject, those activities should also be described in the informed consent form as well.
Thanks for that overview, Cindy. So lastly, the new guidance also includes 16 new FAQs that address a variety of topics within the guidance. We don't have time to go over all of them, but we did want to go over at least one to demonstrate the type of information provided. So one FAQ covers and clarifies considerations for enrolling non-English speaking subjects. The guidance states that investigators and IRBs should carefully consider the ethical ramifications of enrolling or excluding prospective subjects when a language barrier may exist between the investigator and some or all of the prospective subjects. The selection of subjects should be equitable, and the individual should not routinely be excluded from participating in research simply because they do not understand English. The guidance says that IRBs and investigators must ensure that the information given to such prospective subjects is in a language understandable to them. When translation and interpretation are needed for written and oral information that is to be presented to subjects, the FDA recommends in this FAQ that the IRB review and, if appropriate, approve reasonable procedures for ensuring that the translations will be prepared by a qualified individual or entity and that interpretation assistance is available. So overall, this new guidance solidifies that there is a push toward both modernization of clinical research as well as the willingness to incorporate and utilize new technology in relation to the informed consent process.
Sponsors, IRBs, and clinical investigators should take note of this new guidance and expect additional changes to FDA's informed consent regulations and guidance upon FDA issuing the final rule together with the common rule. And with that, we conclude this Triage episode. Thank you so much for joining us.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. we would love to hear from you.